This is Joey Spalazza from the J. Harris Academy of Police Training with another roll call video. Here, we're going to review U.S. v. Jamar Hunter. This is a Third Circuit Court of Appeals decision, December 5th, 2023. Can we, as law enforcement, use a criminal record check lasting approximately 2 minutes? Will that be an objectively reasonable safety precaution related to the mission of the traffic stop under Rodriguez v. United States and the Fourth Amendment? The routine traffic stop lasted less than 8 minutes. It began with a police officer spotting minor motor vehicle traffic violations. Neither the reason for the stop nor the legality of the stop at its onset is disputed. Trooper patrolled alone without a partner or backup and approached the car to discover 2 occupants. Hunter was the driver and Davis was the front seat passenger. After Hunter and Davis provided identification, the trooper returned to his patrol car to perform routine license and warrant checks. This revealed that both men had valid driver's licenses and no outstanding arrest warrants. Hunter argues that the mission of the stop ended at this point, and the trooper no longer had constitutional authority to prolong the stop. Immediately after this routine check, the trooper performed a triple I check that extended the traffic stop. He spent about 5 minutes conducting both checks in his patrol car, with the triple I check taking approximately a minute or 2. The triple I revealed that both Hunter and Davis had significant criminal histories, including firearm and drug trafficking convictions. Armed with this information, the trooper returned to Hunter's car. The trooper ordered Hunter out of the car so he could perform a Terry frisk. He discovered a loaded Glock 45 semi-automatic handgun in Hunter's waistband. He immediately arrested Hunter. The entire traffic stop lasted less than 8 minutes. Hunter moved to suppress the gun seized during the traffic stop, claiming that the trooper's use of the triple I check impermissibly exceeded the traffic stop's mission, and thus any evidence recovered after the triple I check should be suppressed under the Fourth Amendment. The district court granted the suppression motion based on the following. The trooper lacked sufficient reasonable suspicion before conducting the criminal history check. The criminal history check was unrelated to the traffic stop mission. The criminal history check prolonged the traffic stop, and the criminal history check therefore impermissibly exceeded the stop's mission and violated Rodriguez and the Fourth Amendment. The government timely appealed on 2 grounds. The district court erred when it applied a subjective standard review and therefore erred as a matter of law in concluding that this criminal record check was an off-mission detour pursuant to Rodriguez and the Fourth Amendment. In granting the suppression motion, the district court erroneously applied a subjective standard rather than the constitutionally required objective standard. Specifically, the district court considered Trooper's subjective testimony that he routinely, but not always, performed the criminal history check during traffic stops. The district court credited Trooper's testimony that he would sometimes employ this check to bolster reasonable suspicion. Grounding its reasoning in its subjective testimony, the district court concluded the criminal background check was thus not tied to the traffic stop's mission. Was the criminal history check objectively reasonable and proper? To be reasonable, a traffic stop must be justified at its inception and throughout the length of the stop. Officers' actions during the stop must be reasonably related to the mission of the stop itself. Rodriguez defines a traffic stop's mission to include completing tasks tied to the traffic infraction, such as issuing a traffic ticket, checking the driver's license and any outstanding warrants, and inspecting registration and insurance. Rodriguez also permits use of certainly negligibly burdensome precautions when done to complete the mission safely. Off-mission detours that do not address the basis for the stop or legitimate safety concerns, such as dog sniffs or extensive criminal history questioning, violate the Fourth Amendment when performed without reasonable suspicion. Here, the parties agree that the criminal history check does not qualify as a routine task tied to the traffic infraction, and the government concedes that the trooper had completed the task specifically tied to the traffic stop when he finished the driver's license and warrant checks. The government argued that the check was objectively reasonable under Rodriguez because it was part of the stop's mission due to officer safety. Officer safety has been a long-standing and recognized concern of the United States Supreme Court. Arizona v. Johnson. Traffic stops are especially fraught with danger to police officers. U.S. v. Rodriguez also recognized this concern and concluded that officer safety interest stems from the mission of the stop itself. Rodriguez explained, An officer may need to take certain negligibly burdensome precautions in order to complete his mission safely, and they implied that conducting criminal record checks could be done in furtherance of officer safety. If in fact there is more than one occupant in the vehicle, it increases the possible harm to the officer. Post Rodriguez, the 1st, 4th, 7th, 8th, 9th, and 10th circuits have all concluded that a routine criminal record check during a traffic stop is lawful under the Fourth Amendment. When necessary in order to complete the mission of the traffic stop safely, a criminal history check is permissible and within the bounds of the Fourth Amendment. This criminal record check, which lasted approximately 2 minutes and was supported by objectively reasonable safety concerns, was a negligibly burdensome officer safety precaution that falls squarely within the confines of the stop's mission, according to Rodriguez. Under other circumstances, a criminal record check may be unreasonable if it is more than negligibly burdensome and thus exceeds the stop's mission. The district court ordered the motion to suppress to be reversed. The case is remanded for further proceedings. It should be noted that the Terry frisk itself was not challenged. From all of us at the J. Harris Academy of Police Training, stay safe. Happy holidays.